For more on this, let's bring in legal expert Mpumelelo Zikalala. Thank you very much for joining us this afternoon. Quite an important story that we have been tracking for months now, and it was quite interesting to see the distinction that Nandi Phamagudumana's attorney or legal representative wanted to make between an extradition and a deportation, and why it is important in the case that she is putting before the judge. Maybe just explain that for us. Why was that important for the judge to hear?
It's important. Good afternoon to you and also to your viewers. It's important because the procedure that has to be followed in the two avenues in which we secure the attendance or the return back of the individual into South Africa is important. Firstly, let's start with an extradition, which is more elaborate and much more that needs to be done. If you say there's an extradition, you go into that country and you say to them, I need this individual to come back to South Africa to face certain charges which they are facing. Here's the list of charges that I have, the amount of witnesses that are there. There's reasonable or prima facie evidence that says we have the correct individual, hence we need to test these in a court of law. But I do give the assurance in the country in which I'm making the application in that that person is going to be treated with the utmost respect. They are going to be given their right in order to be able to defend themselves, which is the right to al alteram partem. Even right to legal representation would be afforded to them. Look at our constitution in South Africa under Section 35. These are the other rights that we give to individuals that are accused individuals. But most importantly, if indeed they are found guilty, they are not going to be given a death penalty, which is usually a deal breaker in this type of extradition applications. Give them back to us so that they can continue and to go on their matters. The importance for that, or the benefits that the accused or the person who's being extradited then gets, is that they'll get information as to what is it exactly that they're being looked for, get an opportunity to state their case or defend their particular extradition application. So it's a lot more elaborate, a lot more detailed than what a deportation would usually do. Now, if you move over to deportation, it's a lot more simpler for the country in which is seeking the return back of the individual. It simply means you are being ejected from Tanzania. Tanzania is saying, because you are here without the adequate papers, we do not want you here. We are going to deport you back to your country. Your country will deal with you in whatever manner. In terms of internal procedures that need to be followed, it's all in Tanzanian-based. Even the Director General, if I'm not mistaken, is the one that takes the decision in there, and everything is done in terms of deportation. So there are no court cases. There are no appearances in front of any judge. There's no submission as to the strength or weakness of the case in which they are going to face. It's simply a question of saying, you don't have the adequate papers, we're deporting you back to South Africa.
And so what leg does she have to stand on then by putting that argument that you've just broken down for us forward, in that she also was in the country illegally alongside Thabo Bester and the other culpable person that was arrested alongside them?
I think the main line that she was trying to put was to say, look at the context and the manner in which this thing has taken place. It is an extradition disguised in a deportation. So the procedures that were followed are not procedures that ought to have been followed had an extradition or proper extradition process been done. But the defense from the South African side is simply to say, we cannot dictate how the Tanzanian government will deal with illegal individuals that are in their country. We serve at their behest. If they say to us, we are simply going to deport them and we are going to benefit from that because it's less elaborate, then that's what it is. We are beneficiaries of the decision of the Tanzanian government. We can't tell them what to do. We can't tell them as to the manner in which they should orchestrate themselves. So, yes, we've benefited. Maybe we could have gone the other way, but we are not responsible for the decision that they've taken. So, you can't then impute any injustices that you may allege have taken place to us, because all that we have done in South Africa is to facilitate your moving or your deportation process from Tanzania up until we came to South Africa. If you have any issues, maybe those issues ought to have been raised within Tanzania, but the amount of time that you have had and resources would have definitely worked against you. But we can't be blamed if we did not intentionally participate or try to intentionally circumvent an extradition process so that you could be able to benefit. That is what the court will have to deal with and decide upon based on the evidence which was submitted to it. But it does seem as if even if there were level of negotiations were not simply to say, we want to circumvent the elaborate process of extradition. It was a process of saying, Tanzania, we're in your hands. What do you want to do? Do you want to deport or do you want to extradite? And Tanzania was saying, we want to deport. These people are here without any proper papers. They're not even on holiday. So on what basis are we going to negotiate with them if they are not here on proper authority, on proper papers?
And then on the other side, a lawyer representing the Department of Home Affairs arguing that there's nothing wrong with the two governments coordinating or engaging on this particular matter to have her deported. And so there were the argument that it was a deportation disguised as an extradition is baseless. What did you make of the argument that was put forward by those representing the Department of Home Affairs? Was it a strong enough one to stand against that of the defense?
It was correct, because you have to look at this case within its circumstances. Here you have someone who does not have papers to be in Tanzania. So truly speaking, it's up to the Tanzanian government to simply decide how do they want to deal with them. Now, whenever there is a South African who is found in Tanzania, obviously the embassy would be contacted. However, if there are individuals that come from that particular country, and you can be able to negotiate with them or talk to them on one-on-one basis, that's exactly how things are going to do. So the mere negotiation, the mere talking or any exchanges of any assurances between the two countries is something that cannot be regarded as a circumvented extradition. It is done, or it occurs on a regular basis, and it can't be taken that because this is this case, it must have been that they were trying to circumvent things or certain processes that were meant to be handled within the extradition process. If the case was, we have a person that has proper papers to be in Tanzania, they are saying that I do not want to be extradited or sent back or deported back in this manner, then maybe they could have a point. But I seem to align myself with the submissions made by the Home Affairs officials or at legal representation in terms of saying it is a normal process that takes place. Two countries have got a long-standing collaborative relationship between them. And when things happen in this manner, that's exactly what we do. If you come back to South Africa, we almost engage in a similar thing, which is why we have a Lindela in Gauteng, if I'm not mistaken, that if people who are not meant to be in South Africa, they stay there before they're deported back to our country. So deportation is a proper and legal process of sending back a person to their country, and there's nothing untoward about that. I think that's what they were trying to lament to the court, to say, we want to remind you, Judge, that this is a process that we engage in. It is not something which is untoward. It has been done before, and it cannot be in any circumstances be regarded as a disguised extradition.
Yeah, and of course it's important to understand that it was not reported that she resisted her arrest in any way. And another component of that is that if she is contesting the manner in which she was arrested by Tanzanian authorities, our courts would not have jurisdiction or authority to rule on that because we don't follow Tanzanian law. So it is a little bit more complex than one would see with the naked eye.
Definitely, and that's what the court will have to decide in terms of saying, what is it that we must assess? Must we assess the conduct of the Tanzanian government, which is something that we can't do, or we must assess the conduct of South Africans that were in Tanzania and the manner in which they negotiated? But keeping in mind that the final decision maker in all of this process would have been the Tanzanian government. So if they so decide that we're going to deport someone, we have no authority to tell them and say, go and conduct a forced extradition process or engage in it so that you can be able to comply with the law. We're simply going to accept what they say and execute based on that. So it's important for us and even the court to understand that particular matter. But another point which that comes in when you speak about the manner in which she was arrested is that is the element of agency which the court will have to look into tomorrow and then say, is this matter urgent? By saying, is the irreparable harm which is going to be suffered, taking into account that harm has already been suffered. So the occurrence of harm is not on its own something that can be taken as that saying that urgency does exist. But most importantly, are there other alternative remedies that are there? What is she seeking? To be released, and also the charges should be trumped, which I don't see the court aligning with that. But if the point is to be released temporarily, the point is to attain your freedom. There is bail proceedings which are available within the court that she's appearing in. And on a number of occasions, the opportunity has been afforded to her, and she's the one that has said, I do not want to partake in. I do not see the court saying that we are going to release you because there's a procedural fault that took place within your arrest. Even the merits of what you are arrested for are not going to be considered anymore. It would be a huge and a drastic decision for a court to take that, to issue out that court order.
Yeah, and that's a very interesting point that you raised, because she could have sought proceedings that would afford her bail. Does the indication that she chose this route rather than bail, I mean, you alluded to it a little bit earlier, would that have meant that she would have been released temporarily and the charges would have been dropped, as opposed to her being on bail where the charges would still stand? Maybe just give us the differentiation between the two different scenarios here.
Let's start what she's seeking for, which is the number one price of saying that because these are fruits from a poisonous tree, in that I was extradited, deported, disguised as an extradition. Hence, my being here is not supposed to take place in any case. So, from that basis, due to my arrest being so illegal and so unlawful in contravention of all the constitutional provisions that are there, let me go and regard me as a free lady, which is something which I don't think the courts will align to, because there are merits, or there is a reasonable question that we need to answer at the end of the day in the allegations that you are facing. So you can't be let out on a technicality. Go and answer and deal with those within the appropriate court. And there's an opportunity for that within the trial stage. Now, you can't engage or argue with that if you don't have the proper papers which are in front of you, which would have meant that she would have stayed in jail if she does not apply for bail. The exchange of the docket would have taken place. The manner of arrest would have been some of the documents within that would have been in her possession. She's then able to distinguish between the two, but nonetheless deal with the merits of the matter in which she's being faced with. So if you then say on what she's applying for now, the court order that she's looking for now, release me because my arrest was improper, I do not think the court will allow that to happen. But the court will consider the following in terms of saying, if you would have applied for bail, you would have been out, provided that you have complied with the provisions of Section 6 of the Criminal Procedure Act. The onus is on you, by the way, to prove all those factors that are there. So that's within your control as to how much do you want to provide to the court. But then you are released on bail. You are able to create or to prepare your defense in an appropriate manner, including the defense of the improper arrest or the unlawful arrest that you are alleging now. So wait for the proper forum, wait for the proper documents in which you can be able to provide to us, and then we'll be able to make a proper assessment. Again, this works maybe against to advantage, because as the applicant, the onus is on her to prove on a balance of probabilities that whatever that she's alleging is indeed true. Now, you can't say that two people, because you have seen them discussing or talking about something, they are then colluding to engage something which is illegal. We have to provide much more detailed evidence and mere allegations, and which is what she has done in affidavit. So I think that the court will also look into that and say, there are alternative remedies that you could have engaged. You can't then say that the matter is urgent, but we'll deal with the merits of the matter just for the sake of making sure that this is an important matter, so that we're able to allay the fears either to you as the applicant and also to the Republic, to say this is how we viewed it. There's really no urgency which is there, but nonetheless, there are still merits that we still need to answer to, and go and allow the proper process or the alternative dispute resolution forum to deal with it at a later stage.
Thank you very much for that breakdown, Mpumelelo Zikalala, for this afternoon. He's a legal expert, and of course the judge, Judge Lobsha, is expected to make his ruling tomorrow. And of course you've got senior reporter Slindelo Masikane, who has been covering the story and will bring us the developments as they unfold.